Hello, everyone. It's so great to see everybody here today. We're so pleased we have over 100 RSVPs from y'all who are joining us here at Food for the Poor for this exciting webinar. And of course, we're being streamed on Facebook as well, so welcome to y'all as well. I hope today is going to be very informative for you. We've got an excellent speaker. I think we've got a lot of great material and good discussion points to just discuss and talk about general issues and perhaps things that'll be helpful to you as you're thinking about maybe planning your estate or perhaps updating your estate plan, which is something that we all need to do at one point in our life. So without further ado, we want to spend, of course, much of the time with Dr. Adam Goldberg, who we're so pleased to have as our guest today. But we like to begin at Food for the Poor with all things keeping prayer in mind. And so we will center ourselves. And I'm very pleased to introduce Barbara Burns, who is a member of our Legacy Society. She's going to be leading us in prayer. Our Legacy Society here at Food for the Poor is a really special group of people. We're about 1,300 strong across the country. And those are people who have heard God's calling in their heart to include food for the poor in their plans, either as a beneficiary designation for, say, a retirement account, their will, or perhaps even a charitable gift annuity. But it's a very special group of people, so we welcome you all today for those members that are here. And welcome you, Barbara. Thank you for leading us in prayer.
Thank you so much. First, a scripture, Proverbs 3, 5, and 6. Trust in the Lord with all your heart and lean not on your own understanding. Acknowledge him in all your ways, and he will direct your paths. And the reason I say that is because it's a plural word, it's paths, which means that it could vary from time to time. So let's go to the Lord in prayer. Heavenly Father, we come before you now, and Lord, we trust in you. We accept the facts that we are here in this broken world. But Lord, there are ways to fix it, and you are our extreme fixer. You're a fixer-upper, you're our maintenance, you're our guide, our leader, and walking before us, around us, and covering us with the sweet smell of good peace and prosperity. As we go through these days, we ask that you would bless each and every participant in this place, on Zoom and Facebook. We ask that you would bless each and every one of the people who work at Food for the Poor and who are beneficiaries, as well as all of our partners. And we ask all these things in the name of Jesus Christ, our Lord and Savior. Amen.
Amen. Thank you so much, Barbara.
You're welcome.
Well, what can I say? We want to spend most of our time with Dr. Goldberg, as I've mentioned. There's so many great things to say. I'm tickled pink to be sitting across from him in our studio here at Food for the Poor. I've known Dr. Goldberg for some time, and he's an incredible person with a lot of integrity, as well as having a real breadth and depth of experience in the estate planning area, and also has an extensive practice working with nonprofit organizations like Food for the Poor around the country. He holds not only a Juris Doctorate, but a doctorate in education from Nova Southeastern University here in Florida, as well as an LLM degree, which is a master's in estate planning from the University of Miami, which is one of my alma maters, so pleased to have him there. He's an adjunct professor as well at the University of Miami School of Law, Nova Southeastern University School of Law, and Florida State, for all you FSU fans out there, for their School of Business. And like I mentioned, he's written numerous publications and lectures around the country extensively. I could go on, but I will just add he's been named a Florida super lawyer in tax every year since 2017. And we're just thrilled to have his expertise and his extensive background with us here in the studio. So without further ado, Dr. Goldberg, why don't you take us through some of the basics?
Well, thank you again for inviting me to speak here today. I'm sure my mom loved that introduction. So I think it's more information than anybody else needs. So we're going to talk about estate planning. And what I want everybody on this call, on the Zoom, in the Facebook Live, is to realize that estate planning is not the same for everyone. Estate planning is different. It's customizable. And it's also optional. If you choose not to do any planning of any kind, the state of Florida or the state of Arizona or wherever you reside will fill in the details for you. For some people, estate planning might be doing a simple will that just says who's going to be in charge of my minor kids if anything happens to me. For some people, estate planning might be irrevocable trusts, where we're worried about state taxes and federal taxes and maybe international property. So it's different among different people. Among the celebrities, we've seen interesting estate plans play out. We've seen the singer Prince with no will of any kind, despite having 11 different lawyers. For those of you in the Northeast, you might remember the hotel heiress Leona Helmsley and how she wanted to leave so much money for her dogs. Even sometimes it's not about the money. In the Robin Williams estate in California, they were fighting about pajamas, trophies, and bicycles. So again, estate planning is different depending on what any particular person's needs are. We named this conference Where There's a Will, There's a Way, so it's a good starting point to talk about what is a will. And again, we have people from all over the country on this call, so remember some of the rules in Florida are very different than some of the other rules. If you might reside in a state where a will requires 3 witnesses, whereas some require 2. If you're in Louisiana, there's a will that requires 7 different types of witnesses. So do realize that each state is going to have some specific rules. And depending if you're in California, Nebraska, or New York, there may even be some localized rules depending on the county or the city that you live in. So a will is the most basic document you can do. It is not required to have an attorney. You could write one on a cocktail napkin if you wanted to. I've seen that done before. But there are a few requirements no matter where you are. A will must be in writing. Doesn't need to be typed. It could be written in purple crayon if you like, but it must be in writing. Louisiana is one of the few states that does admit oral wills. A will, in order to be valid in most jurisdictions, including Florida, must be signed at the end of the document. It must be witnessed by 2 people. Some states, like I said, require 3, but for Florida, it's 2 people. Those 2 people do not have to have had read the will, but they do need to know that a will is what the person is signing. And they should be over the age of 18 and have mental capacity. Once you've done those things, you have a valid will in most jurisdictions. It is even better if you get that will notarized, because that will allow the will to be admitted to the court in a faster process, and we'll talk about that process in a minute. Once you've done a will, if you've chosen to do a will, you should put it in a secure location. We've learned during COVID that might not be a safety deposit box, because sometimes those have gotten very difficult to get into. But a waterproof, fireproof box that you've bought at your favorite hardware store, office supply, or a warehouse store for $45 or so would certainly be a good start. And it's also nice to make sure that somebody knows where to find the documents. According to True TV, which used to be Court TV, only 1 in 3 Americans, or about 30% of the population, have a will of any kind. That means that about 70% of the population is letting the state that they live in define their estate plan for them. And like I said, that's perfectly fine. In Florida, the example would be if you're married with no kids, the state of Florida assumes you'd want to leave everything to your kids. If you have a spouse and kids from a prior relationship, the state of Florida presumes you'd want to leave half to your spouse and half to the kids. The state of Florida also assumes you'd want to leave those kids the assets the day they turn 18. Again, with no documentation, the state of Florida fills it in for you. The purpose of a will is perhaps to change that to reflect your personal preferences. Let's talk about the advantages of a will. As I just said, the advantages of a will is it's very easy to do, and it should be relatively inexpensive. I'm not adverse to will software packages, will online packages, if that's the only type you're willing to do. Again, it's better than nothing, whatever help that you can get. A will can be changed at any time. I do have clients that come to see me once every 6 months because, this child did that or their gardener did this, and they want to make changes. But generally, we encourage our clients to look at their wills every 3 or 4 years. Obviously, there's one thing that would change that, and that is a change in preference, a change in law. There can be changes in the tax law, the state law, the federal law, a change in family, hopefully for the better, new grandkids, fun, happy daughter-in-laws, son-in-laws, and what have you. But it does go the opposite way. People die. People are no longer part of your life. Sometimes it's just a change in finances. Obviously, good things. You won the lottery. Some relative you never met left you a whole bunch of money. You got a big promotion and a big bonus. Those would all be reasons to revisit your will earlier. And then, of course, again, sometimes you want to do it just to see if there's been changes in procedure. Other advantages of a will is it has no homework. Once you've done the will, you can set it and forget it. Using an advertisement from from television. You put it aside, and again, every so often you take a look at it. It's not something you should be reading every single day. In states like Florida, you cannot deposit the will with the court until somebody dies. That's not true. In states like North Carolina, you can deposit the will with the court while you're alive. That does mean if you wanted to make a change, there's an extra step in the process. Wills have no power until you're dead. So at that point in time, that is the first time that a will comes to light. And we'll talk about the process in just a moment. In Florida, wills are subject to probate, but let's quantify and qualify that statement. Let's define probate. Probate is the process by which assets owned in the decedent's sole name are transferred to beneficiaries while keeping in mind the claims of creditors. I'm going to repeat that. Not that this is a classroom, you don't have to write it down, but I do want you to understand it. So probate, and this is true in all 50 states, is a process by which assets owned in the decedent's sole name are transferred to beneficiaries while keeping in mind the claims of creditors. Let's analyze that for a minute. If I die and I have a house that I own jointly with my wife, and I have a life insurance policy that my wife is the beneficiary of, and I have a bank account that has my brother's name on it, when I die, there's no assets in my sole name, provided those people were all alive, and therefore there's no need to do a probate. I have listed beneficiaries on all of my assets, assuming that was all of my assets. Again, one of the ways that you can avoid needing a will, if that's the route you wish to take, is to make sure that you have beneficiary designations on all your accounts. We'll talk about that in more detail in a few minutes. But like I just said in my little example, if we have other people, other names, and those people are in existence on assets, I might not need to have those subject to probate, and they wouldn't be subject to my will. A perfect example is if I did a will leaving everything to Food for the Poor, but my wife's name was on the bank account and she survived me, that bank account is going to my wife. We're never getting to the will because the will only deals with assets in the decedent's sole name. Let's talk about the probate process because that is a question I get very often. Probate is something in California and Georgia, it's a very light and easy process. In states like New York, New Jersey, Connecticut, Maryland, and Florida, it can be a more extended process. It can eat up anywhere from 1% to 3% of the assets for expenses and costs. And some states like Connecticut actually charge a fee based on the amount of assets subject to probate. Most states don't do that, but that's a weird little wrinkle for Connecticut. So probate is not necessarily something to be feared. There are a lot of clients that like to avoid probate. Avoiding probate is making things easier for those that survive you. Another way to avoid probate that's very popular, and what most people probably think of, is a revocable trust. In some jurisdictions referred to as a living trust or a family trust, or back when I was a student called an AB trust sometimes, if I go back that far. But a revocable trust is another technique, another document that you can use to distribute assets and to put people in charge when you're gone. The big difference between a will and a trust is the big difference between driving I used to say Yugo, but nobody knows what that is anymore. So driving, let's say, a little Honda versus perhaps driving a Cadillac with all the bells and whistles on it. They both do the same thing, but they do it in different ways. With a will, like I said a few moments ago, there's no homework. It's signed, it's done, you put it away, hopefully you won't need it for a long time. With a trust, there's homework. You're taking care of things now so that things will be easier when you're gone. It's a matter of perspective. With the will, easy on the front end, more difficult on the back end. With the trust, more difficult on the front end, perhaps easier on the back end. Let's just define trust for a minute for those of you that don't know what a trust is. And the best way I can do it is to use the definition I would use if I was sitting in a kindergarten classroom. And I'll give you a formal definition, and then I'll give you the easier definition. If we look into the Internal Revenue Code, it defines trust as an arrangement created by a will or during life whereby an individual or an entity takes title to property for purposes of protecting or conserving the property for the beneficiaries. It's a very nice, effective definition, but I think we'll go with an easier one. It's a separation of ownership and enjoyment. The trustee of a trust, the person in charge of the trust, is technically the one who owns the trust assets. The beneficiary is the one that enjoys the trust assets, hence the separation. There are certain types of trust where certain people can wear both hats for at least a little while, but it's beyond the purposes of what we're going to talk about today. There are a number of advantages of a trust. Obviously, we can avoid that court procedure on the back end, probate, if we have properly funded our trust. That also would lead to some privacy concerns because whereas probate is a public process, a trust administration can be a private process. Wills are easier to contest than trusts because wills have a forum, that probate court, that a trust would not. It is more difficult for creditors to get paid from a trust than they would be from a will. It's also easier to rule from the grave. Let me explain that term. It's not Halloween, but what we're talking about there is people have passed on, but they want to continue to control the process. An example would be I have two brothers. One might be a spendthrift and one might not be able to spend a penny from his pocket. I may not want to give all of my inheritance to my brothers when I pass. I may want to space it out for them, maybe based on age or passage of time. So I'm continuing to control their enjoyment of the assets I left them, even though I've been in the ground or cremated for an extended period of time. That's ruling from the grave. There's always going to be tax issues, both income tax and estate tax. When we ask questions in this area, I like us to be a little bit more specific. This is one of my bugaboos. I don't like to hear the word tax without something attached to it. So depending on what jurisdiction you live in, there might be gasoline tax, state income tax, state inheritance tax. Maryland and Minnesota have an inheritance tax. Parts of Nebraska, certain counties have an inheritance tax. And then there's the ones that we're more familiar with, capital gains tax, income tax, estate tax, gift tax. There's something called generation skipping transfer tax, which we have time we'll talk about in a little while. Trusts offer a few more advantages. They offer us some ways to postpone estate taxes. They're a very good use for planning for incapacity. And it's also a good use because they have a wider range of the people that you can name to be in charge. If you find yourself in Florida with a will, we have something called personal representative. That is the politically correct way of saying the person in charge of a will. If you're in the Northeast, you're going to be more familiar with the terms executor or executrix. That's just Latin for female person creating a will or male person creating a will. But Florida uses the gender-neutral term personal representative, and a lot of states are following with that. So personal representative in Florida has to be a blood relative or a Florida resident. So my best friend in Georgia could not serve. But with a trust, I don't have that restriction. So if I want my best friend in Georgia to be in charge of my estate and trust matters, I would definitely need to do a trust over a will because I'm choosing a fiduciary that would not otherwise qualify. It wouldn't be fair to talk about advantages of a trust without talking about disadvantages of a trust. The 5 most common disadvantages are, number 1, always going to be cost. I wish I could tell you that a trust and a will cost the same. But like I said, with a trust, all the homework is being done up front. So that's where the bigger fee is going to be, as opposed to just doing a will. Flexibility for change. With a trust, you actually need to go through the process of making changes to the trust, which would likely require 2 witnesses and a notary. So it's not something that can be changed quickly, although it is something that can be changed easily. A trust is going to take more time for somebody to understand, both the person that's creating the trust, which in Florida we call settlor. In some states you might hear the term grantor or trustor, and also the beneficiaries or the trustees. So it does take some time to understand. It certainly is more difficult to establish. It usually requires some field trips, a trip to the bank, a trip to the brokerage house, a trip to a real estate attorney, perhaps to do a new deed. And one disadvantage that's also an advantage is the lack of judicial oversight. What do I mean by that? Why is it both? The lack of judicial oversight is great because it makes things happen more quickly and at less cost. However, I have some clients that have 4 kids that don't get along at all, and they refuse to pick one or the other. So sometimes having judicial oversight might be a good thing. So that's why it's an advantage and a disadvantage. Let's talk about irrevocable trusts. What we talked about before was revocable trusts. An irrevocable trust is a trust where you are limited on what changes you can make. It doesn't mean the whole thing has to be irrevocable. Normally for an irrevocable trust, it's normally the beneficiaries that are the one thing that cannot be changed. But it depends on what the trust document says. You may have the right to change the trustee, change the assets that are in the trust. There's a very famous case, if you're in Louisiana, the former owner of the New Orleans Saints kept putting his football team in and out of trust. And whether or not he had the ability to do that. There's some case law on that if you're interested in following up on that. Normally, when we're doing an irrevocable trust, we are doing it for 4 primary reasons. The first reason is for tax avoidance. Both it could be income tax or estate tax or gift tax or generation skipping tax. So usually one of those. Another reason might be to avoid creditor claims. So if we're worried about creditors when we pass away, we can use irrevocable trusts to perhaps limit the ability of creditors to attach against our assets. A big one is to avoid litigation, as an irrevocable trust is more difficult to challenge than a will or a revocable trust. And the time we do it most often is when we have a special needs beneficiary. I hope none of you out there have someone that needs that, but that might be someone who is on government assistance or is in a position where they are not allowed to have large sums of money under their name, and we have to take special care for them. So that's why we might use an irrevocable trust. Let's talk about some other documents that are part of, again, estate planning. But again,
Yeah, can I jump in right here?
of course.
Dr. Goldberg, you're sharing a lot of really great information. Can I just point out that we invite anybody in the audience to go ahead and post a question if you'd like a clarification question or have another question. This is probably bringing up a lot of great topics and ideas among all of you. So we have a chat both in our Facebook live stream and here on the webinar. If you scroll to the bottom of the screen and hover your mouse on the bottom, you'll see the chat room. So thanks so much, because this is great information. I'm sure people will have questions.
Good. Happy to answer any questions when we have them. So let's talk about some documents that are not financial in nature for just a minute. And these documents are going to have different names in different parts of the country, but we're going to stick with Florida for the most part now. And that'd be a living will, also called an advanced healthcare directive, casually known as the pull the plug document. We're not going to get into the details of it, but part of an estate plan is deciding how you feel about those things and putting in something in writing so that your family, your clergy, your doctors, your medical staff know how you feel. There's also something called the Do Not Resuscitate Order, a DNR. This is not something that is often available in every state in the union, but this is something different. This is, hey, I've had 5 heart attacks, and the next time I have a heart attack, I don't want you to try and get me better. Don't lay a finger on me. That's what a DNR is, Do Not Resuscitate Order. In Florida, it's funny, they have to be on yellow paper, and we normally have been told if you have one in the house, you're supposed to put it on the fridge. And the EMTs are supposed to look on the fridge and see if they see any yellow paper before they try and make you better. So that's the way it's supposed to work. I hope none of you have to go through that and find out for sure. But those are not the same thing. A living, you see on the, if you're watching the screen here, a living will is something different. So that's more for a long-term illness, end-stage condition, whether or not we're going to keep you all alive with the equipment. Whereas a DNR is don't lay your finger on me, normally part of a hospice package. That's a great conversation for another day, but I want you to be aware of those. The next document that sometimes is part of an estate plan would be a healthcare surrogate or a healthcare proxy, again, depending on what part of the country you're in. This is who would make medical decisions for you only if you cannot make them for yourself. So assuming that you are in a position where the doctors or the medical staff can't get you in a position to make an educated answer, this tells us who is the person or persons that should be making these decisions for us. And on all of these documents, and I was remiss in not saying, whenever we're appointing a fiduciary, we always want to get into the habit of appointing backups as well. I've seen many documents where a husband appoints a wife and the wife appoints the husband, but they don't tell us what to do if the husband or the wife is no longer there. And that's not an effective document. So we always want to be thinking about contingencies and naming others. So a healthcare surrogate or a healthcare proxy might make a decision on what rehab center to go to, whether or not to approve an experimental treatment, what pharmacy to use. Again, only if the person doesn't have the ability to make those decisions themselves. Now something a little newer. If you haven't updated your estate plan in 5 or 8 years, you might not have heard of this. This is a HIPAA release form. This is a document that allows you to access medical records for a person. So I always send my clients to Hawaii for this example, and we assume they're in Hawaii and they chip their tooth, and the dentist that they go to in Hawaii says, I'd like to see your dental records from your dentist in Florida. Well, if we have a HIPAA release form, somebody can walk into that dental office, show the form, and they could get the records and Federal Express them to Hawaii or scan them, if that's possible, to Hawaii. So a HIPAA release form is very important for accessing medical records, and as time goes on, hospitals and doctors' offices will get more strict with that. I also want you to realize, for my people in the audience that have teenagers, I want you to think about what we call in my office a college kid special. That's not anything formal, but what it is making sure if your kid is going off to college and they're going to be, more than maybe, 100 miles away, think about having them do a power of attorney, which I'll talk about in a minute, but more importantly, a healthcare surrogate on a HIPAA release form. So if something bad happens, the medical staff will talk to you. If your child got into Yale University and they're up there and they get into a car accident, all the police are going to do is tell you your child's been involved in an accident. They're not authorized to talk to you because chances are that child is over the age of 18. So don't always think about estate planning just for you. Sometimes it's for those that are a part of your life. If you have a grandma's attic in your house and grandma's living with you, you want to make sure that you have paperwork so that somebody has the authority to speak for grandma, both maybe on a medical basis or a financial basis, if grandma can't speak for herself. That leads us to the last of the primary documents, and that's a power of attorney. Now, powers of attorney are very state specific. What you can do in New York is very different than what you can do in Florida. But what generally a power of attorney is, you are giving somebody else the power to handle your financial matters in the event that you can't, or unfortunately in Florida, immediately. These are probably the most powerful of all the documents that I've talked about, especially during someone's life. And the best example I can give you is a sad one. Unfortunately, here in South Florida, we often read about people that maybe had very little family, and they gave a power of attorney to their neighbor or a distant cousin, and 3 months later they find out that person closed all the bank accounts and took all of their assets and maybe even deeded the property out from under the poor person. And those are unfortunate, but a power of attorney has that authority. You are giving someone the authority to step into your shoes for financial purposes. And in Florida, it's a power that's effective immediately. And a lot of people don't realize that. If you come from up north, you might be remembering springing powers of attorney. which are documents that say this document is only effective when it's accompanied by 2 doctors saying I can't handle my affairs or something along those lines. But that's not the way it works in Florida. If any of you have done a real estate closing, you might have signed a special power of attorney. A special power of attorney is a power of attorney just to do a particular act, like attend closing and sign paperwork. Or it might have been a special power of attorney over a particular type of an account. Maybe I have an account at Bank X, and I've given my son power of attorney over account X. So, lots of different types. The word durable in durable power of attorney means it survives incapacity, which is really when we want it. If you don't have a durable power of attorney, that might mean, depending on what the document says, because titles aren't always exact, that you have a power of attorney that dies off when you become incapacitated. That may or may not be what you want. So I certainly would want to encourage you to take out the document and take a look at it. Let's talk a little about something called federal wealth transfer taxes. I wish this upon all of you because only 0.1% of the population right now is subject to the federal wealth transfer tax. This is a tax, and there's 3 taxes. The federal estate tax, which is a tax on the privilege of transferring wealth at death. The federal gift tax, which is a tax on the privilege of transferring wealth during life. And something called the generation skipping transfer tax, which is a tax on the privilege of transferring wealth at death or during life to somebody that is 2 or more generations below you. So think grandchildren and great-grandchildren. I don't want to spend a lot of time on this because chances are very few of us on this meeting are affected by this. But the first $12,920,000 that you have if you're a U.S. resident or U.S. citizen isn't subject to the tax. So if you're married, you've got almost $26 million before you have to worry about this tax. However, if you are in a position to worry about this tax, the tax is a 40 cents on the dollar tax, 40%. So if I die with $12,920,001, in theory, I will owe 40 cents of tax, 40% on that $1. And this is a tax that's due, the federal estate tax, 9 months after date of death. Now, for those of you that are in states, like I've said before, Connecticut, New York, Maryland, Minnesota, Nebraska, you might have and New York especially, you might have a state level of this tax. Florida does not. There is no Florida estate tax. There is no Florida gift tax, but a lot of states do have. About 11 states have. So be aware. That's one of the reasons why Florida has been so popular lately is people are leaving high tax jurisdictions for low tax jurisdictions. And Florida has no state income tax and it has no state estate tax or no state gift tax. Let's talk about I'm going to go back to my kindergarten teaching days, some yucky topic, okay? Burial and funeral decisions. This is part of estate planning. Some people have very strong feelings. Some people have very religious principles, and it's very important that they be buried in a particular location or facing a certain direction, or that they not be cremated, or that they do be cremated. So this is something that's very personal. To some people, this may not matter. To others, it may matter a lot. And I really want you to think of the loved ones that you're leaving behind here. It may not matter to you, but it may make a big difference to them. And as much as I'd love to tell all my clients to prearrange this, that's not always possible, but at least let your family know what your wishes are, okay? If your wishes are to be cremated and have your ashes spread at sea, great, but let them know, because once we cremate you, we can't bury you someplace else, and we've seen that sometimes. Some religions get very concerned about having all the body parts. So if somebody had a leg amputated, where is that leg? We need to have the whole body buried. Some people want to be their ashes mixed with the ashes of their animals. And in some states you can do that, but a lot of states you can't, at least not officially. Disney World and places like that are well known for people trying to deposit ashes there. The Masters Golf Course in Atlanta is another place. So sometimes there's a code for that, and they shut down the ride. The Haunted Mansion, Pirates of the Caribbean, according to Disney, and It's a Small World are the three most popular rides that get shut down because they find somebody distributing somebody's ashes there. So those are some interesting ones. Remember, the prices always are going up there, so that's another reason to consider doing it. Let's talk about creditor and asset protection. I'd love to spend a lot of time on this topic, but Florida's a really good place to live if you owe people money. Bernie Madoff's wife lives in Boca Raton now. O.J. Simpson desperately wanted to get back to Florida. So I want you always to have something in mind regarding asset protection. I want you to be aware, and for those of you can see, you'll see the slide up. Homestead is something very unique to Florida. There is something equivalent to New Jersey and Texas, but that's about it. That basically states that most creditors cannot touch your homestead real property. So your primary residence cannot be taken by a credit card company that you owe money to or a hospital that you didn't pay. There are a few exceptions to the rule for if you don't pay your real estate taxes, you don't pay your HOA or condo dues, or you let a builder come in to make some improvements. But for the most part, your homestead's going to be protected. Annuities and life insurance in Florida are another great asset. We have a lot of our doctor clients, a lot of lawyers, anybody that in a field that with a lot of malpractice. Those are more assets that cannot be touched for asset protection purposes. There are also some great for using charitable giving, which we'll talk about in a minute, and also retirement accounts in Florida. So that's one of the reasons why a lot of doctors and a lot of accountants and lawyers and financial planners try and put as much as they can in as many different retirement accounts, because in Florida, the retirement accounts cannot be touched for asset protection purposes by outside creditors. Retirement accounts, by the way, are a great asset to use for charitable giving. So remember that when I give my retirement accounts to my kids, especially if it's not a Roth IRA or a Roth 401k, they might pay anywhere from 10 cents to 39 cents on the dollar when they take the money out. But if I was going to leave something to Food for the Poor, they get 100 cents of every dollar. So that's definitely a good asset to be thinking about when you're thinking about leaving assets to charities. And charitable planning would also be part of this process as well. Nobody gets out of my office without getting asked the question, is there any assets you'd like to leave to your favorite church, temple, charity, school, or other organization? So I always want you to be thinking about, are there any charitable giving that you'd like to do? As we get towards the end of the formal part of the presentation and we open it up for questions and answers, just a couple of other little things I want you to keep in mind. Asset titling. That's something that a lot of people just kind of willy-nilly pass over. You know, our kid is 18 years old, they're going off to college, and I want them to have a car. So we put mom's name on the car with the kid. Very dangerous. If the kid gets into a bad car accident, mom's on the title to the car. Now mom's assets are at risk, you know, to a judgment or to a lawsuit. We also see it with housing. You know, person couldn't necessarily qualify on their own for the mortgage, so mom and dad or grandma is on the title to the house with them. And now what happens when grandma dies? Are there tax issues? Are there creditor issues? Is it affecting our homestead for my Florida people in the audience? Lots of different ways to own property. The most common we see is something called tenants by the entirety. Most common is joint tenants. Joint tenants means that both people own the assets. When you have joint tenants with right of survivorship, that means the last to die owns it all. So if I had a joint tenants with right of survivorship with Elizabeth Welch sitting across the table from me on a piece of property and I died first, because it had that right of survivorship, I can't give any of that to my wife. That property is going all to Elizabeth. Tenants in common is what we just talked about. You know, no right of survivorship. If I have 10 people, tenants in common, we all own 1/10 of the property. Tenants by the entirety. That is the best way to own assets in Florida. If you're married, this is going to be true in most jurisdictions, because we each own an undividable 1/2 interest. So if I do something stupid and get into a car accident, but the property they own is tenants by the entirety, and I hopefully didn't have my wife on the title to my car with me, they can't touch that property because it's tenants by the entireties. So my wife has a 100% indivisible interest in it, and I have a 100% individual interest. So that's a good way to own property if you are married. A couple of other terms I'd like you to know. Probate, for probate avoidance and the way you own things. ITF, POD, and TOD. Let me go over what those mean. And they all mean the same thing, but they just stand for different things. And it's on the screen for you if you can see the screen. ITF is in trust for, POD is payable on death, and TOD is transfer on death. They all mean that the way I own the asset is it's mine for my lifetime, and the minute I die, whoever's at the end of that term is who it goes to. So if I own property in trust, ITF, Jamie Goldberg, then when I die, it goes to my brother, Jamie Goldberg. If I own property, I own a bank account at Bank of America, Adam and Elena Goldberg, TOD, Jamie Goldberg, then when both of us are gone, my wife and I, Jamie Goldberg goes into the bank with a death certificate and he gets that account. It doesn't matter what the will says. It doesn't matter what the trust says. It is the asset listing a beneficiary. Very similar to, in a smooth transition right into, life insurance and retirement accounts. Always want to make sure that you know who the beneficiaries are for your life insurance and your retirement accounts. For retirement accounts, that would include 401ks, 403bs, SEPs, IRAs, Roth IRAs. And you want to update those. I see a lot of clients that had grandma and grandpa as the beneficiary because their kids were too young at the time and they've never updated them. The worst ones are when I see the ex-wife or the ex-husband as a listed beneficiary on those because they've never been updated. So that's definitely something you can do on your own. You do not need a lawyer, accountant, or anybody to help you with that, but you should know who your beneficiary designations are for all of your accounts that have them. Annuities would be another example of an asset that you own that likely has a beneficiary on it. Remember that it is very easy to change the beneficiaries. It's a change of beneficiary form. Most organizations now have that online for you, and you can take care of it that way. And I would want to encourage you to do so. I see we're getting towards the end of our time.
We're doing good. We
Okay.
have some questions in the queue,
Okay,
but please finish up. This is great information.
I'm gonna wrap up here with a story. It's a little bit of a long story. So we go back to the initial question. Why do I care about estate planning? And this is a great story. It's a story that I use to answer that question, but you'll have to bear with me because it's going to take a little bit of a setup. So long ago, I had a client who owned a restaurant. It was open only on Monday to Saturday, and he worked it 6 days a week, so Sunday was always his off day. He had an aunt that lived in Southwest Ranches. For those of you that know Southwest Ranches, maybe you're in South Florida, it's a community where there's no deed restrictions. You can't have less than 1 acre. And you can put whatever you want on your lot. If you want to build a train set in your backyard that you can ride on, you can do it. If you want to have goats or ostriches, you can do it in Southwest Ranches. It's in the southwest part of Broward County. So he had an aunt that had lived there for a very long time. She had been single all her life, and she had handed him an envelope many years ago and said, "Open this envelope if I die." And he was the closest relative to her. So he called me up one day and said, "Yo, my aunt just died." And I said, "Okay, didn't you tell me about an envelope?" "Yeah." "Did you open it?" "No." So I said, "Open it." So he opened it up, and it was a will. Very simple will. I leave everything to my nephew, Mr. X, and I put Mr. X in charge. And the will was properly witnessed and properly notarized, and we had the original. So we probated the will, or so we thought. There was a house in the aunt's sole name, and that's one thing we were aware of. We went through the house. Every Sunday he would go to the house and start cleaning things up, getting it ready for sale. But the one funky thing was we never could find any bank statements. And we kept checking the mail, and I kept saying, well, something should come soon, and nothing came. So then we ordered copies of her tax returns, which we can do for the last 7 years, and we found out she didn't file any tax returns. Not necessarily a bad thing. She didn't have any income to report. Okay? And now I'm getting more nervous, and I'm like, all right, let's bring a locksmith in, and we start trying to find some safe in the house somewhere. And, we're not knocking down walls yet, but we're getting there because we've got to figure this woman had something. We weren't finding any large deposits of cash anywhere. And then I said, okay, you're going to have to start taking a day off at the bank, from the restaurant, and start visiting some local banks and bring the death certificate and the court authorization, and maybe we'll get lucky. Nothing. the lead, the story that broke the case. We went to pay the water bill, and the lady knew the decedent and said, "Oh, how's she doing?" And when we told her she died, I go, "That's so sad." And it occurred to us, how did she pay her bill? Oh, she brought cash in every month. Okay, there's cash somewhere. So now, hard target search of the house. Again, getting ready to start breaking down walls, and we're looking under beds. And, I've seen people wrap money in aluminum foil behind the oven, and we are moving things and nothing. We finally find in a refrigerator in the garage a Sprite can that's one of those fake Sprite cans you used to be able to buy at the novelty shops. In it was a survey of property of the house with about, 90 or so X's on it. Well, what did we do? And I was there the first time he did it. We dug up one of the X's. And what did we find? An old ragu can with about $3,000 in it. So for the next few Sundays, the nephew every Sunday would go out there and dig up the X's, and he would find an old coffee cup or something, and it would have cash in it. She was a Holocaust survivor. I didn't say that in the beginning, and she didn't trust the banks. When all was said and done, almost $400,000 in cash was found. So that is truly an interesting estate plan. Now, if you're going to do it that way, please tell somebody or leave the map in an easier to reach location. I wish you would have put that map in with the will. It would have saved us a lot of heartache. In closing, I tell extreme stories. I know it makes the points more fun. If you've gotten nothing else out of this presentation, what I'd like you to do is please just pull out your existing estate plan. Take a look at it. If you haven't looked at it in a while, just make sure it's still what you want. If you have somebody you love working with, then by all means, go visit them again. And if you don't want it, then just understand the state of Florida will fill in the details for you. And, let your kids know the few little parts that aren't going to show up in the state of Florida won't make a decision for you. With that, are we ready for some questions and answers?
I think we are. And that goes for any state because we do have people from all over.
Wonderful.
The state will make your decision for you if you don't.
Yes, it will.
So that's great. Well, Patrick Flavin, I had the honor of meeting him and his lovely wife, and they were excited to attend this webinar. So they have a question. The first one, to put one in the chat. If he and his wife already have a will,
Okay.
but they are considering a gift to Food for the Poor, and they're wondering, how do you do that if you want to change your will? Do you have to completely nullify your original will, or how do you make changes of that nature?
Okay. I'm going to answer the 30 years ago answer and the more modern answer. 30 years ago, before the computer was as easy as it was to use, we would do something called a codicil. A codicil is an amendment to your will. It is executed with the same formalities, and you don't have to make any changes to your will. We now read your will and the codicil. So the codicil might say, before you distribute everything to my 2 children, I leave $35,000 to Food for the Poor. That's a very easy thing to do. And even though I said it was 30 years ago, you can still do that today, but you want to make sure it's signed with all the same formalities. So in Arizona might be a 3-witness state. So if you had 3 witnesses to your will, you would want to do that with a codicil. The disadvantage of that, of course, is you have to read the will and the codicil. In my office, we have a 3 codicil rule. After 3 codicils, I don't want to, and you can see me stacking papers here, I don't want to have to read 11 different or 12 different documents to figure out what's going on. With the advent of computers, it's just so much easier to just do a new will, especially if you go back to the same person that did your prior documents, because it should be a very easy change, and now you only have to read 1 document. So the answer to your question, and I realize it was a very long answer, is it can be done by doing a new will, or it can be done by doing a codicil, which is an amendment to a will. And the same would be true for a trust. It would just be a trust amendment as opposed to a trust. And when you redo a trust, it's called a restated trust in most jurisdictions. So I hope that answers your question, and I thank you for breaking the ice and asking the first question.
Wonderful. All right, from Chris Wallace. Can I pre-appoint a guardian for myself in the event that I'm not mentally able to care for myself before the state is? How does that work in regards to, powers of attorney and other estate planning?
All right, great. It's one of the documents we actually didn't talk about, so thank you so much for bringing it up. In most jurisdictions, including Florida, you can do something called a pre-need guardian form. This is actually 1 page. It's actually a very simple document. And it states, if ever I am in need of a guardian to be appointed for me, either guardian of the person or guardian of the property, X is the person I would want to be appointed for me, or you can only do one at a time. I can't do X and Y. You could do X, and then in the event X couldn't serve, you can do Y. Couple things to realize. Number one, this document is not a guarantee document. What do I mean by that? It is just stating what your wishes are. It doesn't mean the court will necessarily choose the person that you picked. And also, we need to know that form existed because in Florida, we can't deposit it with the court in advance. In North Carolina, you could. So that would be part of your documentation. And you, again, you'd have that important person in your life that knows if anything happens to you, this is where to find the paperwork so they can go. I'm not a big fan of giving paperwork to kids and family early because it makes it a little bit more awkward to make changes, but that's a personal decision in everything. So hopefully that answers your question, Chris. It's called a pre-need guardian form. You should be able to find one in the state of Florida online for absolutely no cost. And it is a good thing to have if you have some strong feelings. I'm just going to build upon that for a moment. It's more, I find that form to be more important if you have minor children. Who would you want to be the guardian for the minor kids in the event that both parents are gone and you have children still under the age of 18? Realize in Florida, in order to serve as a guardian, you have to get fingerprinted, you have to pass a criminal background check, and you have to be willing to submit to the jurisdiction of the court where this is taking place. So thank you for that question. It's an excellent point, and it's certainly a form I probably should add to this presentation.
Excellent. Okay. And from Sharonette, how does one deal with handling funds in an account where a family member is deceased but never designated any beneficiaries?
Okay, so this brings us to our probate process. So normally in that case, the bank will have frozen the account. It's possible that statements are still being mailed. The bank, at least in Florida, would normally hold that account for 2 years, and then it would send it to the state of Florida, where Florida would put it in their treasure hunt. And if you want to write that, an interesting website, fltreasurehunt.org. And every state has one. New York's is very difficult to use, but Florida's is fltreasurehunt.org. And the money would stay there for 10 years waiting for it to be claimed. And if it's not claimed after 10 years, then the state of Florida gets to keep it. So how do we make sure that doesn't happen? You're going to have to do a probate. In Florida, if it's more than $75,000 and the first 2 years, it'd be a formal probate. If it's $75,000 or less, or the person has been dead for 2 years, it's a summary administration probate. Unfortunately for our non-attorneys in Florida, you must use an attorney for the probate process. You're looking at costs in Florida that should be, $400 or less. Legal fees of hopefully, $1,000, give or take a few dollars in one direction or the other. But that is the process you're going to have to go through. No matter if the money is still with the bank or if it's now with the state of Florida, you're going to have to do an administration. If you found yourself in California, there's an administration by affidavit. They also have one of those in Georgia, but Florida doesn't offer that right now. So unfortunately, in that case, it's a probate, and you want to get it done at some point in time because, like I said, after a certain point in time, that money would go to the state of Florida, and I'm sure that's not what Grandma would have wanted in that example. So great question. Thank you.
Ah, very good. Now we have one from Immaculata Sanchez. I'm going to try and summarize this for you,
Okay.
Immaculata. She had her mother, who was suffering from dementia, had a trusted family member, and she gave this family member a very large amount of money, and then, of course, doesn't remember it subsequently.
No.
The family member hasn't said anything about receiving the money. There's obviously no solid proof one way or the other. So how do those sorts of situations get sorted out?
Okay, so this is something we didn't talk about. This is not probate issues because this was done while somebody was alive. In Florida, this would be known as a tortious action, and the cause of action would be tortious interference with a devise or tortious interference with a bequest. I'm going to set it up for everybody that's listening. Imagine that Mom left a will and a trust leaving everything to me, her only son. But prior to Mom dying, her brother came and had her put him on all of the assets. So I get 100% of the will, which is 0, and I get 100% of the trust, which is 0, because my uncle is now on all the accounts of my mother. So there is no way to track this because that's not information I would necessarily be privileged to. And there's no way, unless I had power of attorney and did it before mom died, to get access to that. So it's actually a personal cause of action against the relative or against the person for intentional interference with a devise or intentional interference with a bequest that would allow you to do discovery, and I'm not going to get it heavy into litigation here, but that would open the doors for you to do discovery to find out bank records, tax records, and actually even subpoena the bank to say, when did this happen and how much money was in the account? These types of cases can be very expensive and very time consuming. And if they're going to be brought, they need to be brought quickly, because obviously if the person has spent the money or put it someplace that you can't get to it, then the disadvantage is great. You have a judgment that you spent all this money getting and now it's worthless. There are a lot of attorneys out there that would take these cases on a contingency fee. That means that you'd only have to pay attorney's fees if they collect something, and those attorney's fees can be anywhere from 30 to 40%. And so again, I would encourage, if that's the case, the sooner to act, the better. You probably want a commercial litigation type of an attorney, or perhaps a probate and trust litigator would also work in that scenario. But certainly start writing. My immediate advice would be write down everything you know, talk to every family member and write down anything they know. And one easy thing you can do is you can get a copy of the tax returns. So that'll show what accounts existed at one point in time. So just to have an idea.
Excellent. Okay, I'm going to add in another question that's probably on a similar topic, because we see this a lot in Florida or any state where there's a lot of retirees. One of our donors has an elderly parent who was, allegedly manipulated by a caregiver and did a quitclaim deed to her property. So does that fall into the same category of tortious?
They're very similar, but with real estate, there's a timeline. You've got to act faster. Okay? Because after a set period of time, and I wish I had my real estate partner here, so shout out to Jacqueline Revis and my other partner, Chris Voss. She could answer this better than I could, because it's hard to be a jack of all trades, but I want to say it's 2 years, and maybe she'll call in or text us the correct answer, but after a set period of time, it can't be changed. So it's considered that, you have good title here. So we do see that happen. It's happened unfortunately a good amount of time here. One of the best things that people can do if you live in Florida is most of the counties in Florida have a free system you can sign up for, where if there's a change to the deed, you can be notified, or you can have other people notified. It's very similar to what I just said before. So intentional interference with a devise or intentional interference with a bequest. But that one is because it's real property, and that person can then, sell it to somebody else or transfer it or take out a loan against it. It's critical that you move even faster in a case like that.
Thank you. Excellent advice. We had another question about what happens here in Florida. We have what's known as a homestead exemption, which deals with real estate property taxes. What happens to it when the person who owns the property dies?
That's a great question. I teach a 2-hour class that answers that question. So we're going to try and do it in 2 minutes or less. Homestead doesn't die just because the owner of the property died. Your homestead can carry on in 2 ways. Number one, your property continues to be exempt from the claims of creditors. So if you owed Holy Cross Hospital, $500,000, and you died, but the property was your homestead when you died, they can't get even if your beneficiaries sell that property, they can't touch it. It's still your homestead. So homestead survives death provided you didn't ruin it. Ruining it would be forcing a sale. If your will or your trust says, sell my primary residence, then go run to see an attorney immediately. You should never do that because it kills the homestead. The price you pay for that protection, though, is you are limited on what you can do with your homestead. We didn't talk about prenuptial agreements or postnuptial agreements. The state of Florida limits what you can do with your property if you're married or if you have minor kids. So if I pass away and I own my property and my wife lives in that house with me, that property has to go to my wife for at least a certain point of time, either for her lifetime or she can sell it and take half the assets unless she signed a prenup. So there's 5 aspects to homestead. This covers 2 of them. 1, at death, you still get the protection but you're limited on what you can do and who you can leave the property to. If I had a will leaving it to Food for the Poor, you would get nothing because I can't give you my homestead if I have a wife or minor children. That can be changed for the spouse in a prenuptial agreement or a postnuptial, but you can't play too much with the kids if they're under the age of 18.
Fantastic. Well, I think we're coming to the close of our hour. I certainly want to thank Dr. Goldberg for joining us. If we did not get to your question, please know that we'll try and reach out to you. If you registered for the webinar, we'll use the contact you information you sent. If not, we're going to go ahead and pop up my contact information on the screen. I'm Elizabeth Welch. I think I neglected to introduce myself at the top of the hour. I'm a legacy and gift planning advisor here at Food for the Poor, here to be of service to you for all questions, answers. So feel free to call. We've got an 866 number on there. And of course, you can email the questions as well. We have also recorded this webinar because I think there was so much information. I know I learned a couple of new things myself. You might want to sort of fast forward or pick a particular topic to run through. We will certainly follow up via email if you've sent us that during the registration process, or just shoot me a quick email and we'll get that to you. We've got some great resources to share. I think one of the things I always encourage our donors to think about, as you heard on this hour, there's a lot. Every state is different, every situation is different, and there's a lot to consider. So we certainly encourage you to get with your professional advisor to talk through all the particulars of your circumstance. If that's not an option for you, we do have at Food for the Poor a special partnership with an online software package that Adam mentioned that is definitely better than not doing anything at all. So we're going to go ahead and send that out to you guys via email after the webinar. If you're joining us just on the phone, please do call into Food for the Poor at our 866 number, and we would be happy to get that resource to you as well. So thank you again for joining us. We really appreciate all that you do and for serving those who have so little and suffer in extreme poverty. You're a very special part of our community. We appreciate you. We pray for you every day here at Food for the Poor. And please, again, reach out if we can be of service. God bless.